I guess our request is either A, that the state be required to plead with more specificity what it is that they think is reckless, or alternatively, the reckless portion be struck from the indictment.
Welcome to a case that hinges on one word: recklessness. What exactly counts as reckless when someone's life is on the line? Today, we're diving into an aggravated assault case where defense attorney Mr. Gertz tries to dismantle the state's case before it even hits trial. He claims the indictment lacks the crucial specifics required by law, but the prosecution fires back, saying this is how it's always done. So who's bluffing and who's got the law on their side? The courtroom gets tense, the judge isn't, pulling punches, and by the end of this clip, someone walks away with a serious advantage going into trial. Buckle up, this one's a legal chess match you don't want to miss.
All right, this is cause number 24 DCCR 0094, and for the record, Mr. Gertz is joining us via Zoom, and sir, you are Austin Jones?
Yes, Your Honor.
And Mr. Jones is also joining us via Zoom. The case is set for trial to begin with jury selection next Monday afternoon. It is the only case left on the docket, so it will be the number one case for trial next week. Mr. Gertz filed a motion to quash the indictment, so I wanted to go through that so everybody knows where we are for next week. Mr. Gertz, I want to ask,
All right, let's break this down. A motion to quash is basically a request to throw out part of the charges because they're either too vague, legally invalid, or unfairly prejudicial. In this case, Mr. Gertz is zeroing in on the word reckless. He says it's too broad, too generic, and that the prosecution hasn't spelled out exactly what the reckless behavior was. It's like accusing someone of being bad without saying what they actually did. Legally, that matters a lot, because in Texas, when it comes to recklessness, the law demands specific conduct, not just vague accusations. So, is this just smart defense lawyering, or a desperate attempt to weaken the case before it begins?
it appears it says you're asking the court to excise the defective portions. If you'll explain what you're specifically asking for and what you think is inappropriate.
Sure, Judge. So as you know, aggravated assault of this nature, where it pleads serious bodily injury, allows the prosecution to plead intentional conduct, knowing conduct, and then reckless conduct. In this instance, the problem is the reckless portion of the indictment is not matched with appropriate language specifying the nature of the recklessness as required under the statute, under Article 21.15. And so I guess our request is either A, that the state be required to plead with more specificity what it is that they think is reckless, or alternatively, the reckless portion be struck from the indictment going forward such that they can only proceed on intentional and knowing conduct.
Now here's the prosecution's play. We always do it this way. Sound familiar? It's like trying to win an argument by saying, because that's how it's always been, but the defense is saying legally, that's not good enough. If the law requires specific details for reckless conduct, then boilerplate language even, if common, might not hold up. Think of it like this. The state's painting with a broad brush, but in court you need a fine point pen when it comes to criminal charges. What do you think? Should tradition outweigh precision?
Mr. Hoffpower?
Your Honor, we're tracking the statute. This is how we file all aggravated assaults. They all have, those are in the statute, the three.
Can y'all hear Mr. Hoffpower?
Am I speaking loud enough?
There's the.
I can hear him fine, Judge.
Okay.
Knowingly, I mean, this is part.
I can hear him fine.
The statute of aggravated assault, it always has knowingly, intentionally, knowingly, or recklessly. I'm not sure why, in this particular case, we need to excise that. I mean, that's always how we file that, and it's tracking the statute.
So, from
I'm
my
not sure.
reading of the indictment, and we're all obviously making assumptions, isn't something that we should do, but I would think that the reckless, to me, it would read, that any of those, intentional, knowing, or recklessly, that the action of those is the shaking with the defendant's hands. So how is that not specific enough? I guess my question, Mr. Gertz. Oh, I can't hear you. You muted yourself.
Sorry, I apologize. The answer is, Judge, this case that I cited in my my motion, State versus Rodriguez, requires the state to provide the acts and circumstances surrounding the allegations that the state intends to prove were reckless.
Now this is where things get serious. Mr. Gertz references a powerful precedent, State v. Rodriguez, which says you can't just say how something happened. You have to explain why it was reckless. For example, saying he fired a gun isn't enough. You have to say he fired it near a crowd or in a reckless context. So when the indictment just says shaking caused harm without explaining why that's criminally reckless, it may not meet the bar? Do you think shaken, alone, without intent, should qualify as a felony-level aggravated assault?
And it goes on to give an example of saying recklessly discharging a firearm by pulling the trigger on a firearm which contained ammunition and was operable is not sufficient. That kind of language that just says that essentially an injury was caused by this mechanism is not sufficient to describe why it's reckless. What's the gross deviation from the standard of care that an ordinary person would normally apply here that he has knowledge of? And that's just not contained in the pleading.
I'll respond quickly, Judge.
Yeah.
And I'm not sure about this particular case, but I have had one of these before in regards to reckless deadly conduct, where you understand, like, there's a felony and a misdemeanor, and recklessness is a part of that particular charge, which makes it whether or not, whether it's a felony or whether it's a misdemeanor.
Here's the heart of the matter. Article 21.15 of the Texas Code of Criminal Procedure. It requires the state to spell out the acts that make something reckless. Not just say it was reckless, but tell us how and why. This law protects defendants from surprise accusations and gives jurors clarity. Think of it like a recipe. You can't just say bake something, you have to list the ingredients. And right now, the defense says that recipe is missing key ingredients. But is the judge buying it?
But to my knowledge, there's not analogous to what we're talking about in our case, which is an aggravated assault with a deadly weapon, in which we do give I think we pled the case sufficient.
I think if it had, so I'm looking at Article 2115, which obviously says that it must specifically have to do with this one, recklessness and criminal negligence, that the act or acts relied upon to constitute recklessness must be alleged. I'm going to deny the motion to quash. I believe the indictment alleges sufficiently
And there it is, motion denied. The judge rules that the indictment is specific enough for trial to proceed. That's a major win for the prosecution. But let's be clear, this doesn't mean the state's case is bulletproof. It just means the defense has to fight it at trial, not knock it out before. You can almost hear the disappointment in Mr. Gertz's voice. But he's not out of moves yet, and, as we'll soon see, he's already planning his next legal strike.
Acts of shaking with defendant's hands as the potential or alleged reckless or intentional or knowing, but I think there's enough specificity for the defense to know what is alleged that his client either did or omitted from doing with regard to the recklessness. So I am going to deny that motion. Is there anything else that you guys know of that we need to kind of be prepared for before jury selection on Monday with regard to any other pretrial issues?
No, Judge, as far as I'm concerned, that was my only issue.
Okay, so we will, if anything comes up, just y'all know how to get in touch with me. Let me know. We can take care of it. Either if it has to be taken care of before voir dire, we'll do it. If not, we'll do it that afternoon after we go through jury selection. All right, so we'll see y'all back here.
And Judge, just so you know,
Smart move here, Mr. Gertz isn't backing down. He's officially preserving the right to raise the issue again during trial, if the evidence opens the door. That means this entire debate about recklessness might come roaring back when the jury's watching. It's like planting a legal landmine, silent for now, but explosive later. This shows you just how tactical courtroom lawyering really is. It's not just about what's said, it's when and how you say it.
Go ahead.
Judge, just so you know, I may raise this issue again as the trial progresses. I just needed to preserve it 10 days in advance under the statute. And so I understand the court's ruling but depending on what the evidence is, et cetera, I may raise it again.
Okay.
Because I anticipate what's going to happen, Judge, is that the experts for the state are going to try to allege intentional conduct. And again, part of the problem part of the problem with this statute is it allows them to do all three. And so I'm just letting the court know that I'm going to be likely raising it again, depending on what the evidence is. So
Okay. We'll take that up at the appropriate time if it happens. Mr. Gertz,
I
can you
appreciate
also,
it. Thanks, Judge.
would you have your office send an order over for me to, for that motion to quash? They did. Never mind. They already did.
I'm sorry, that's my fault.
Okay.
All right. Thank you both. You're excused, Mr. Jones and Mr. Gertz. See you next week.
Thank you, Judge. We'll see you Monday. Thank you.
So what did we just witness? A high-stakes legal sparring match where one word, reckless, became the battleground for due process. The defense challenged the indictment, citing legal precedent and statutory requirements. But the judge ruled the case could proceed. This means the trial will include all three levels of mental state: intentional, knowing, and reckless. And depending on how the evidence shakes out, that could sway the entire outcome. Now it's over to you. Do you think the judge made the right call? Would you want more clarity if you were the one being charged? Let us know in the comments below. And hey, if you found this case as shocking as we did, make sure to hit that like button, share your thoughts, and subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay sharp, stay skeptical, and keep questioning the system.